A letter sits unopened on a kitchen counter. Third one this year. Same government seal in the corner. The man who lives there tosses it aside, like the others. He's busy. He'll deal with it later. 3 states away, a computer system logs another missed response. No call, no reply, no payment plan. The clock, one he never knew was running, quietly ticks past its final day. Weeks later, he checks his bank balance. It's not what he expected. Thousands of dollars. Gone. Not stolen. Seized. Legally, silently, by an agency that had been trying to reach him for months. This is what happens when the IRS runs out of patience. And in certain accounts, they can take more than you'd think. Up to 35% gone in a single action. Stay with me, because the accounts most people assume are untouchable aren't. Most people believe their bank account is private, off limits, something only they can access. For the average American, that belief holds up fine. But for someone who owes the federal government unpaid taxes and has ignored the process long enough, that belief is wrong. The IRS has a legal tool most people never think about until it's used against them. It's called a levy. Not a lien, which simply marks a claim on your property. A levy is different. A levy takes the money. Under federal law, specifically the Internal Revenue Code, the IRS can seize funds directly from 3 broad categories of accounts: checking and savings accounts, retirement accounts, including 401k plans and IRAs, and non retirement investment or brokerage accounts. Each one operates a little differently. Each one carries its own risk. Start with the simplest, a standard checking or savings account. When the IRS issues a bank levy, the bank receives a form, Form 668A. The bank is legally required to freeze the funds in that account up to the amount owed the moment the notice arrives. Money already in the account, on that exact date, gets frozen. Anything you deposit afterward is typically safe, at least from that specific levy. But here's the part most people don't know. There's a 21-day waiting period built into the law. It exists for a reason: to give the taxpayer one final window to respond, to call the IRS, to set up a payment plan, before the money actually leaves the bank. Most people who lose the money in this stage weren't ambushed. They were warned repeatedly and didn't respond in time. Now consider retirement accounts, a 401k, a traditional IRA, accounts many Americans assume are protected because of their retirement status. They're not automatically safe. The IRS can, in fact, levy retirement accounts. It's considered a more serious step, typically reserved for cases where a taxpayer has ignored other collection attempts for an extended period. But it happens. And when it does, the numbers can look brutal. Because pulling money from a retirement account isn't like pulling it from checking. It triggers a taxable distribution. The plan administrator is required to withhold a percentage for federal taxes before the money even reaches the IRS to satisfy the debt. Typically 20%, right off the top. Add potential state tax withholding on top of that, depending on where you live. Stack a backup withholding requirement in certain scenarios, and the total percentage taken from that single retirement account can climb toward 30, sometimes over 35%, before the taxpayer sees a dime applied to what they actually owed. There is one small mercy built into the law here. Normally, pulling money from a retirement account before age 59 and a half triggers an additional 10% early withdrawal penalty. When the IRS forces the distribution through a levy, that specific penalty is waived. Small comfort when a third of your retirement savings has just evaporated in a single afternoon. The third category is often the most overlooked: standard brokerage and investment accounts. Stocks, bonds, mutual funds held outside of a retirement wrapper. These accounts carry no special protection at all. If the IRS identifies the account and issues a levy, the brokerage firm is legally obligated to comply, liquidating assets if necessary to satisfy the amount owed. 3 accounts, 3 different mechanisms, one common thread. None of them are automatically off limits, the way most people assume. A levy doesn't happen overnight, and it doesn't happen out of nowhere. Understanding that timeline matters because it explains exactly how far the warning signs stretch before any money actually moves. It starts with an unpaid balance. Someone files a return, owes money, and doesn't pay it in full. The IRS sends a bill, CP 14 in their internal language, a notice spelling out the balance owed. Most people who pay promptly or set up a payment plan quickly never hear from the agency again on that issue. But if the balance goes unaddressed, the letters continue. A second notice, a third, each one slightly more urgent in tone, each one restating the amount owed, now often growing with interest and penalties attached. Eventually, the agency sends what's called a final notice of intent to levy. This is the critical document. By law, it has to be sent at least 30 days before the IRS can actually seize funds. It explains, in plain language, that enforcement action is coming if the debt isn't resolved. It also explains the taxpayer's right to request a collection due process hearing, a formal opportunity to dispute the debt or negotiate an alternative before any levy takes effect. This is the window. 30 days, sometimes longer once appeals and hearings are factored in. Enough time for most people to act, if they engage with the process at all. The accounts that actually get levied usually belong to people who didn't respond during any of these stages. Not because the IRS wanted to seize their money, because every other attempt to resolve the debt through cooperation had already failed. Tax professionals who handle these cases describe a familiar pattern. Someone falls behind on taxes during a hard year, a job loss, a medical crisis, a business that didn't survive. The first notice arrives, and it's stressful, so it gets set aside. The second notice arrives, and by now there's a kind of avoidance built in, a hope that ignoring it will make it disappear. It doesn't. By the time the final notice arrives, some people still don't open it, assuming it's just another version of the same letter. That assumption is the single most expensive mistake in this entire process. Because that particular letter starts a countdown that ends somewhere real. A frozen bank account, a retirement distribution nobody asked for, a brokerage account partially liquidated to cover a debt that, in many cases, could have been resolved months earlier through a simple payment plan. The IRS itself has repeatedly stated that levies are meant to be a last resort, not a first response. Installment agreements exist specifically to prevent this outcome. So does something called currently not collectible status for taxpayers who can demonstrate genuine financial hardship. An offer in compromise, allowing some taxpayers to settle a debt for less than the full amount owed, is another option that exists long before a levy becomes necessary. None of these options work, though, for someone who never responds. The system isn't designed to ambush people. It's designed to eventually act on people who've stopped participating in their own case. Which raises an uncomfortable question for anyone watching this with a stack of unopened mail somewhere in their own home. If a letter like this arrived today, would you actually open it? So, what actually stops this from happening? The good news is the exits are numerous, and most of them are simpler than people expect. The first and most obvious is the fastest. Pay the balance in full, the moment a notice arrives, if the funds are available. Most levy stories never happen to people who do this. But for those who can't pay in full, the IRS offers structured alternatives, ones specifically built to prevent enforcement action. An installment agreement is the most common, a monthly payment plan negotiated directly with the agency that keeps a taxpayer in good standing while the debt gets paid down over time. Setting one up, even a modest one, is often enough to pause any levy action entirely. For taxpayers facing genuine financial hardship, unemployment, medical crisis, a business failure, there's currently not collectible status. This doesn't erase the debt, but it does pause active collection, giving someone breathing room until their financial situation stabilizes. For a smaller number of cases, an offer in compromise allows a taxpayer to settle their debt for less than the full amount owed, if they can demonstrate the full balance is genuinely unaffordable. It's a difficult program to qualify for, but it exists, and tax professionals help taxpayers pursue it successfully every year. Beyond these formal programs, there's a simpler layer of protection that costs nothing at all: responding. Tax attorneys and enrolled agents who handle IRS collections cases say the same thing, almost word for word, every time this topic comes up. The taxpayers who lose the most money are rarely the ones who can't pay. They're the ones who never engaged with the process at all. A single phone call to the IRS, made after that first notice arrives, can open a conversation that prevents everything that follows. Even taxpayers who genuinely can't pay anything right now are usually better off explaining that clearly and getting placed into hardship status than staying silent and letting the countdown run out. There's also a practical safeguard worth understanding, specific to the three account types at risk. Retirement accounts, while leviable, are treated with more caution by the IRS than standard bank accounts. Internal guidance generally directs agents to pursue other collection avenues first, reserving retirement account levies for cases involving larger balances or a documented pattern of noncompliance. That doesn't make them immune, but it does mean they're rarely the first target. Brokerage accounts and standard bank accounts tend to be levied more readily, particularly once a final notice has gone unanswered. For anyone currently carrying a tax balance, financial advisors recommend a simple, unglamorous first step. Open every letter from the IRS the day it arrives. Not next week, not after the holidays, the day it arrives. Because everything about this process, the notices, the waiting periods, the hearings, the payment plans, exists specifically to give taxpayers a way out before the account gets touched. The story that opened this video wasn't an ambush. It was the final chapter of a much longer story, one that started with a single unopened envelope. By the time an account actually gets levied, in most cases, the IRS has already tried, repeatedly, mailed notices, waiting periods, hearing rights, every legal off-ramp available to resolve the debt another way. The accounts most people assume are protected, checking, savings, retirement, brokerage, aren't automatically safe once that process runs its full course. But the process is long, and every stage of it offers a way to stop what comes next. If there's a letter sitting somewhere in your home right now, one you've been meaning to deal with later, this is the moment to open it. Because later, for a growing number of Americans, arrives faster than they expect. And it arrives already knowing exactly which account to take from first.